Hello, everyone. Welcome to the first episode of Michigan PIP Monthly. As you know, there are a lot of changes happening in Michigan PIP, and it seems like every week either a new trend is coming out, we're seeing some new argument made by the plaintiff's bar, we're seeing some new tactic by claimants, we're seeing a new case come down from the Court of Appeals or the Supreme Court. Things are changing quickly. Michigan PIP Monthly will be a monthly webinar and podcast that we'll be releasing. I will be the host of Michigan PIP Monthly. That's me there. I am Mark Vanneste. I am a partner at Seacrest Wardle's Troy office, and I chair the Motor Vehicle Practice Group. So with all the changes in PIP lately, things kind of got a little crazy when the first covenant case came down from the Court of Appeals, primarily on the litigation end, but also on from a perspective of handling claims pre-litigation. And then obviously in May, the Supreme Court issued its ruling in covenant, and that significantly changed the way that PIP cases are litigated and also had implications for how claims should be handled pre-litigation as well, given the change in status for providers in those cases. So Michigan PIP Monthly, like I said, will be a monthly webinar and podcast. The webinar will be released on, well, we're going to try to shoot for anyway, the second Tuesday of every month. And then we'll also have a podcast that will be the audio portion of the webinar that you can subscribe to that. That will be live soon. If you would like to be notified when that goes live, please sign up for our newsletters. We'll send out a newsletter when that's up and live, and when you can subscribe to that should be very shortly here. So every month we will talk about kind of the latest case law from that particular time period. It seems like every week or every other week we're getting at least an unpublished opinion from the Court of Appeals that provides some guidance or even new law in regard to Michigan PIP. So we'll be discussing that in the claims perspective and how those cases really affect the claims that you're handling now, pre-litigation, as well as if they go into litigation. We'll talk about PIP pointers, as we'll call them, which will be various aspects of these new cases that come down, and like I said, how they affect the claims that you're handling now. We'll also look at claims trends, which would be things that we're seeing on both, very early in the claims process and later on a litigated claim if it gets to that point. Trends that we're seeing the plaintiff's bar come up with all this changing law. There's constantly new ideas. The courts are changing the PIP landscape, and that's causing the way that claims are handled to be changed as well. So we'll talk about that. And then our real goal here is for this to become an interactive webinar and podcast where our listeners, you guys, can write in, shoot me an email, give me a call, let me know when you see something that you want discussed, whether it's maybe, like I said, a trend, something that you're just seeing on more and more of your claims that you want to talk about or have a question about, or if it's maybe a specific claim, and we can kind of put those circumstances into more general terms and talk about that as well. That's really going to be the point of this webinar and podcast, is to discuss the sorts of issues that you're dealing with on the claims level. So for our first episode of Michigan PIP Monthly, we're primarily going to talk about covenant and what's happened since that came down in May. So needless to say, when that opinion came out, around Memorial Day weekend, by the time we got back from the holiday, providers no longer had a direct cause of action to sue the no-fault carrier. So, of course, the obvious implication of the Supreme Court opinion was clear, but there were other issues that remained to be determined and litigated because they weren't directly addressed by the Supreme Court. One of the first arguments made by the plaintiff bar was that the covenant opinion should only apply prospectively and should not apply retroactively. That means, does it apply to provider suits that were currently pending, or maybe you had gotten a demand letter or a letter of representation from an attorney for a provider on one of your claims? So the first question was, does covenant affect those claims, or is covenant only going to affect claims going forward? Will it only affect those claims where the providers haven't filed yet? And we'll talk about more on retroactivity in a minute. The Supreme Court, in its opinion, mentioned without a whole lot of explanation assignments. So now that brings up a question for the providers that had been getting assignments, which there are some out there. How are those assignments handled? How are those assignments going to affect the provider's opportunity to recover, an opportunity to litigate? What if an assignment hadn't been obtained yet? What if the assignment was obtained after the covenant opinion came down, but it was more than 1 year after the last date of service? What happens under those circumstances? Those were all new questions that we hadn't been forced to deal with prior to the Supreme Court decision. Affirmative defenses are something that we file when we answer a complaint once a claim goes into litigation. So we now had to look at our affirmative defenses and wonder if that was those would be an issue moving forward and how we should modify those. So of course that would affect more claims going into litigation. Now, in regard to the assignments, like I said, the Supreme Court mentioned them without providing any real elaboration on how the assignment mechanism would work. Most insurance companies have in their policies an anti-assignment clause. So in Michigan, there was no dead-on case law on what happens if there's an assignment in regard to a claim that is brought pursuant to a policy that has an anti-assignment clause. So that was a new question that we hadn't really dealt with before. Also, the idea of third-party beneficiary. We knew once the direct cause of action was taken away by the Supreme Court that providers as a party would try to find some other way to bring their claim. And so that became a question. Would providers begin to claim that they were a third-party beneficiary to the insurance contract, meaning that they could potentially bring a claim, breach of contract claim pursuant to that contract, even though they weren't the insured or the insurer? And then another question that came up, some provider suits, they were the principal plaintiff suing the insurance carrier, and others they had intervened where the claimant had filed a suit. So would there be a difference there? Would there be a difference for those cases that were currently pending where a provider was either a principal plaintiff or an intervener? And then moving forward, would there be any difference? Would somehow intervening get them around the lack of direct cause of action? Is there some way that they could use the law to their advantage to create opportunity that way? So, like I said, on retroactivity, this was the first case that came down that was published from the Court of Appeals. And for those of you who don't know, when the Court of Appeals issues an opinion, it's either published or unpublished, generally. And an unpublished opinion is can provide guidance for us at the trial level. The judges in the circuit courts and district courts might look at that and say, okay, this is how I'm going to apply the law, but they don't have to. On the other hand, a published opinion is binding. The trial courts, the circuit courts, and district courts have to follow a published opinion. So it's a much bigger deal when a published opinion comes down, because it's basically, well, we have new law until that opinion is overturned or disrupted in some other way. For example, if the legislature changes the law, then that may change that published opinion. But until something happens, when we get a published opinion, that's the law. W.A. Foote Memorial Hospital versus the Michigan Assigned Claims Plan is a published opinion. So this is the law. So what was this case about? Well, it started as a priority dispute where W.A. Foote Memorial Hospital sued the Michigan Assigned Claims Plan on the 364th day after an accident to protect their rights to collect. They eventually found, the MACP rather, eventually found a higher priority insurer and filed a motion to dismiss the case for that reason. The trial court did dismiss the case, and W.A. Foote Memorial Hospital appealed the Court of Appeals. Now, while that case was pending, while the Court of Appeals was looking over the issues and getting ready to eventually have oral arguments and issue their opinion, Covenant v. State Farm came down. The Supreme Court issued their opinion there. So once Covenant came down, the Court of Appeals kind of pushed to the side the issues regarding the priority dispute, so we will never know what they were going to do there. Instead, they allowed the parties to talk about Covenant. And the first question they asked was, does Covenant apply retroactively? And this was interesting that the Court of Appeals did this, because the Court of Appeals could just have said in a couple sentences, we're dismissing this case, or sending it back to the trial court to be dismissed, rather, because W.A. Foote doesn't have standing pursuant to Covenant. They didn't do that. They actually allowed the parties to litigate this issue of whether or not Covenant would apply retroactively. To me, that shows me that the Court of Appeals has at least some understanding that there is kind of some chaos in the wake of the Covenant opinion, and we can probably expect to see some more guidance like this, where the case isn't necessarily about Covenant. The Court of Appeals made it about Covenant. For some of the other issues, we may have to wait until there's actually a case that goes up to the Court of Appeals based on that particular issue. But in this case, like I said, the Court of Appeals took it upon itself to allow the parties to make this an issue, and they asked, does Covenant apply retroactively? They went through a lot of case law and history about the retroactivity of published Supreme Court opinions, and ultimately they found that, yes, Covenant does apply both retroactively and prospectively. So that just means that Covenant would apply to any cases that were pending at the time it came down from the Supreme Court, as well as, of course, any cases that are filed in the future. So that was really one of the first questions that litigants had regarding Covenant, and the Court of Appeals answered that one pretty quickly in a published opinion. So that's the law of the land for now. This particular question, in my opinion, was a pretty easy answer, and I think that might be why the Court of Appeals addressed it so quickly. The case law was pretty clear that that Covenant would apply retroactively, and in fact, one of the three judges on the Court of Appeals issued a concurring opinion, kind of just saying, did we really need all that analysis? Obviously, there's nothing unique about Covenant. It applies retroactively just like other Supreme Court opinions. But that being said, we now have that nailed down. Okay, so what about assignments? A lot of the assignment issues are still being litigated, and we're seeing some discrepancies in how the courts are handling these. For example, like I mentioned earlier, there's situations where the assignment may have been obtained by the provider after Covenant, so they get the claimant to sign a document saying they assign their claim for that bill to the provider or their attorney. So is that valid? Is it valid if it's more than a year after the last date of service? What if half of the days of service are before that year mark and half are after? What if the claimant had a prior lawsuit that was settled and they released all benefits? What if the provider suit was filed before the release was signed? As you can see, there are numerous scenarios that can play out here, and we're really seeing a lot of difference between different judges and how they're handling those particular issues. So we don't have, like I said, that W.A. Foote Memorial case on retroactivity. That's the only published Court of Appeals opinion that's come down. But we do have a couple of unpublished opinions that have come down that can provide some guidance, even though they're not published opinions, and they wouldn't be. These were very simple opinions. One was Standard Rehabilitation versus Grange Insurance Company in Michigan. This was just a couple paragraph opinion, again unpublished, so no binding precedent, and there really was no law here anyway. But this case was about a fight over IMEs. Basically, the plaintiff was trying to use previous IMEs as evidence during a lawsuit and obtain those as part of discovery, and the defendant objected to that, and it ended up going to the Court of Appeals. That was the issue. Just like the WA Foot case, the Court of Appeals pushed that issue aside, said nothing about it, and instead said, okay, Covenant v. State Farm has come down, so what's going to happen? Well, apparently before oral argument, Grange brought up that Covenant means this case should be dismissed, right? The Court of Appeals still held oral arguments, and at oral argument, the plaintiff conceded that there was no assignment of the claim. So in other words, the insureds, the Grange Insurance insureds, had not made any assignment of their claim, and ultimately, in light of Covenant, because of Covenant, the Court of Appeals found that Grange could have the case dismissed. There was one little sentence in here that may not be significant at all, and again, this is an unpublished opinion. But you do wonder, do they put these words in there for some reason? The Court of Appeals said that the insureds had made no assignment of their claims prior to this suit being filed. Some attorneys have taken that to mean that maybe the Court of Appeals is of the opinion, or at least these three panelists that were in this case, that if the assignment is not made before a suit is filed, it's not valid. I haven't seen a case dismissed on that argument in the trial court, but again, there are numerous issues with assignments, and they're so specific that we will probably see these go up one at a time to the Court of Appeals and get our answers. So that, again, we don't have anything much to go on at this point. Prior to suit being filed, they may have just thrown that in there. That may have been intentional. We really don't know, and we won't until some of these issues get hashed out. So, like I said, there's a lot of other issues too that we haven't had any opinions come down on yet. And one of those is affirmative defenses. Again, I haven't seen this happen on the trial court level yet, but we can be sure that savvy attorneys for the providers will try to argue that if standing was not pled as an affirmative defense, that somehow that prevents the application of Covenant. It remains to be seen if that issue will end up going to the Court of Appeals, but we'll see. The anti-assignment clauses is an issue that certainly will go up at some point. I would say the majority of judges, almost all of them, in fact, in my experience, have found that the anti-assignment clause is not applicable to a post-date of loss assignment. So basically what these courts are saying is that the insurance contract prevents an insured from assigning the right to benefits before the date of loss, but that once the date of loss passes and the benefits are, in the PIP sense, incurred, that the assignment is of the claim of those past due or allegedly past due benefits, and so that can be assigned, and that the anti-assignment clause in the contract does not affect that. That is actually the letter of the law, which has been spelled out in a much more clear way in other states, and we'll see if the Court of Appeals ultimately, or the Supreme Court, issues a published opinion on that particular point. The third-party beneficiary argument that most providers I've seen have at least tried to make in response to a dispositive motion has not typically been successful. The third-party beneficiary standard is pretty high based on Michigan law. I obviously won't get into it in too much detail here, but the basic rule of thumb is that for a party to be a third-party beneficiary, they have to have been specifically contemplated in the insurance contract. And in the PIP sense, obviously, if you have an insured, there's no way to specifically reference, say, an MRI facility or specifically reference some sort of future provider. So generally speaking, that argument has been successful. But again, we can be pretty certain that somebody on the plaintiff's side for providers will eventually want to take that issue up to the Court of Appeals and see if they can make some good law for themselves. And then, of course, the issue of intervention of principal plaintiff is another one that we'll probably see go up at some point. So far, the judges have been pretty consistent that covenant does not provide some ability to be an intervener just because the provider is not the principal plaintiff, and that is really not too surprising. I don't really see any changes there coming from the Court of Appeals, but again, we may see some issue that kind of plays in here. For example, some of these providers are filing a lien or filing, in the claimant's case, filing a lien, or somehow other ways trying to get involved in the claimant's case if they have one going on, which they're kind of almost trying to act like an intervener. So we'll see if some case goes up on that particular point and they find some way to do that. So that's it for our first episode of Michigan PIP Monthly here. Again, please contact me. We would love to hear from you with any questions or comments, and especially questions regarding the claims that you're handling and the issues you're seeing, because that's really what we want to talk about every month. This month was a little more obviously based on covenant and the litigation aspect of things, because that's what covenant affected most, but we want to talk about all these issues in the context of claims that you're handling and how you can apply these new principles that as they come down to the claims that you have on your desk. So, like I said, please feel free to give me a call or shoot me an email. Sign up for our newsletter if you haven't already. Not only do we release newsletters on important cases and other changes in the PIP landscape, on what happened and how it affects your claims, we also will release or announce when our podcast goes live that way. So you're more than welcome to shoot me an email or give me a call for that as well. So thank you for tuning in, and we hope to see you next month and hope to see you subscribe to our podcast eventually as well. Thank you very much.